Is this you with our son?
Yes,
So you did raise him since he was
yes,
a baby, correct?
correct. But he's not my biological son, and you know this.
Do you each solemnly swear that any testimony you give today will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Yes, Your Honor.
Okay, thank you. You can both lower your hands, and counsel for the Attorney General's office.
Julie Damani for the Attorney General.
And I guess, Ms. Lewis, I'll let you proceed since it's your pleading. I've read it, and I understand there's no agreement on it.
That's correct, Your Honor.
You
And Your
proceed.
Honor, before we begin, I did have exhibits 1 and 2, which was just the same thing as attached to the motion. I didn't know if it would be okay to publish it through share screen, or I believe Ms. Damani told me that you have another way that you like for them to be published. Or
Yeah, and Mr. Damani, just so you know, usually if an attorney has exhibits, the way my other offices handle it is they just ask for the link to be sent before the hearing begins, and then they just put it in for them. Because as you well know, it was very hard to set up. Like a lot of AGs are struggling with it. So I don't expect someone who's not familiar with Case Center to necessarily use it in a timely manner. I find it usually takes a long time during the hearings. So I don't know if you have access, Mr. Damani. I guess we can pause the hearing and create one of those now, if that's how y'all want to do it.
Your Honor, if I may, they're attached to the motion. I don't know if that makes any difference. It looks to me like they're the same as what's already attached.
And that's correct, Your Honor. So, I mean, if the court would, I mean, I could ask the court to take judicial notice of it.
I can do that. I take judicial notice of the affidavit and his exhibit 2. Does anyone? I take judicial notice of the affidavit and the time card details that are attached to the pleading.
Okay. Thank you. May I proceed, Your Honor?
You may proceed.
Okay. Mr. Correa, can you please state your full name for the court?
Francisco Correa Barriga,
And where do you currently reside?
1507 Stone Mesa Drive, Houston, Texas 77073.
How long have you lived there?
For like a year and 6 months.
Okay. And were you living at 1507 Stone Mesa Drive on March 26, 2025?
Yes, I was.
Okay. And where do you work?
I work for Admiral Glass Company.
What are your normal work hours?
My normal work hours are from 5 in the morning to about 5 in the afternoon.
Okay. And on March 26, 2025, what time did you report to work?
I was already on the clock and at work at 5 a.m.
Okay. And you have provided documentation via your time card for that week. Is that correct?
Yes, ma'am.
And does that time card reflect you clocking in for work at 5 a.m. on
Yes.
March 26, 2025?
Yes, ma'am, and being out at 5 p.m.
Okay. And have you seen the documentation? Well, let me ask you this. Were you at your home? Was it possible for you to be at your home at 7:02 a.m. on March 26, 2025?
No, ma'am, I was already at work since 5 a.m.
Okay. So if a return of service states that you were served on March 26, 2025 at 7:02 a.m. At your residence, would that be accurate?
No, ma'am, I was already at work.
Okay. Have you ever personally been served with any court documents in this case?
No, ma'am, I have not.
Were you served with any documents on March 26, 2025?
No, ma'am.
Have you ever seen a citation or petition for this lawsuit prior to June 16, 2025?
No, ma'am. That is the
Okay,
day that I saw it on my emails.
Okay. And how many people live at your residence at 1507 Stone Mesa?
There's various family members, male and female, living there.
Okay. And are you aware of anyone at that residence may have mistakenly been served and presented any documents to you of this lawsuit?
Not that I am aware of. No, ma'am.
Okay. How did you first learn that a default judgment had been entered against you in this case?
I was going through my emails and I just happened to see that I had an email from the courts, and that's when I clicked on it and saw the information that was sent to me.
Okay. And when you received that order via email, what did you do thereafter?
I immediately started looking for a lawyer to represent and see what action I needed to take to get this resolved.
Okay, did you ever ignore any legal documents or intentionally fail to respond to this lawsuit?
No, ma'am.
And is it your position, well, had you have been properly served with citation in this petition, what would you have done?
The same thing that I did whenever I found out was immediately seek legal advice and get this resolved accordingly.
Okay, were you trying to avoid participating in this case?
No, not at all.
Okay, now let me ask you, you've seen the default order that was signed in this case, correct?
Yes, ma'am.
And are of the children named in the default order, are you the biological father of all of those children?
No, ma'am. There's one of the children that I am not the biological father to.
And which child is that?
Aiden Jeremiah, Korea.
Now, at the time that this child was born, you and the mother were married, correct?
Yes, we were married.
And you're still married, is that right?
Yes, ma'am.
Okay, and so though you are the presumed father of this child, is it your testimony that you are not the biological father of this child?
Yes, and both me and Miss Norma are aware of
I'm
it.
sorry, I don't mean to interrupt you, but Ms.
Okay.
Correa is making noises. Also, even though you are at home or you're outside, you are in court. So please treat it like court. Please try to get to a stationary location where you can focus on court and not be moving around and not having side conversations during court.
Yes, I am.
You all didn't reach an agreement, so it's real important that everyone hear what's being said. Obviously, you all care enough that you wanted a hearing. You have to participate in the hearing fully. I require that. And then also, we generally take testimony in court. So if you are not the person being asked questions, please don't interrupt or answer or roll your eyes. Wait till it's your turn to be asked questions. If you don't have counsel, you will be given a chance to speak as well. And then, isn't that relevant for this, but I'm not with the Attorney General's office, so anything you've discussed with them or given to them beyond what's been done in court, I have no knowledge of, and I'm not supposed to have knowledge of, so just be aware of that as well. And you may continue, Ms. Lewis. And Ms. Freer, you're in a stationary spot now. You are focused and not having
Yes.
a side conversation. Okay, perfect. Let's proceed, Ms. Lewis.
Thank you, Your Honor. Do you believe that it's appropriate for you to be ordered to pay child support for this child?
No, I'm not the biological father. No.
Okay, and what would you request the court to do regarding this child if this judgment is set aside?
I just get removed from the child support. That what's fair.
Okay, and if the court does set aside this default judgment, what do you plan to do as it relates to the marriage?
We would want to file for divorce and do everything the correct way and get what's needed for the children done and do whatever we need to do to make everything right and get the proper documentation and everything done.
Okay, and would you have claims or requests that you would like to make regarding your property and children and marriage if you had the opportunity to present it?
Yes.
Okay, and no further questions for this witness, Your Honor.
Ms. Damani, do you have any questions for Mr. Correa?
Just one question.
Okay.
Mr. Correa, looking at the time card details attached to the motion to set aside default judgment, it does not have your name on it.
Okay.
Where did you obtain a copy of that time card detail?
We have an app on the phone where we clock in and out, and you have to click by name to show you the correct details.
And so how can the court be sure that that was your time card?
I'm not sure if I can log into it and you see me click my name and it shows the time card. I'm gonna see if I can pull it up right now if there's a different way of showing the name or anything. Give me 1 second. Yes, my name should be at the very top of the time card.
So are you doing this on your computer or on the device, the same device that you're using Zoom on?
No, I'm using another device.
Okay.
So I don't know if I can't screen share it, but I can send it to my attorney and then she can send it to you guys. But it does have my name at the very top. It says Correa Francisco Barriga.
if the court would allow it.
I will allow that.
I just have to click back to the date. Give me 1 second.
If you're able to do it on this device, you could screen share what you're doing.
No, I have it on my work phone. Is the one that has the
Got it.
phone application. Okay. Oh, I don't know. I could if y'all can see it on the screen here. It's Francisco Korea, and then you go to details, and then it shows all the dates and times.
Are you able to go a little closer to the camera? I'm not able to see it.
I'm gonna go back to the page where it shows my name, which will be here at the very top.
Oh.
Sorry.
Ms. Damani, were you able to see that?
I'm still not able to see it. I don't know if Judge is able to see it.
Yeah, you're probably looking at the earnings summary. If you look at the blue section on top, it says his name.
Yes, and then I just go to the details
Is that
for
now,
the
Ms. Damani?
for the week, and then it shows everything.
Yes, thank you. I have no further questions, Judge.
Ms. Correa, do you have any questions you would want Mr. Correa to answer?
Yes. So I thought this was court was about him not getting served, right? But they're bringing up about my son, and I just wanted
Ma'am,
to
your
show.
questions aren't for me. Your questions are to Mr. Correa. Is this a question for Mr. Correa to answer?
So yes. So
Okay.
my question is this him in the photo with me in the hospital?
That is me, but that doesn't mean he's my biological son.
Okay, hold on. One more question. Is this you with our son?
Yes, I'm not gonna neglect a kid, a good father, just because his father wouldn't step up to the plate. Correct.
So you did raise him since he was
Yes,
a baby, correct?
correct. But he's not my biological son, and you know this.
And did you or did you not tell me that it was going to be your way, that he had no dad, you were the dad, we were married, and this was your
Objection, Your
son?
Honor.
Objection as to
Relevance.
relevant. Oh, sorry, relevance.
I'm going to sustain the objection. All I'm addressing today is whether or not I'm going to grant the new trial. So those issues will definitely be at some point addressed, assuming they pursue their claim. But I'm not ruling on that issue today. Do you have any questions regarding the new trial?
Nope, that's it.
Okay. Ms. Lewis, do you have any other witnesses you'd like to call?
No other witnesses, Your Honor.
Okay. Ms. Damani, do you have any witnesses you'd like to call?
No witnesses, Your Honor.
Ms. Correa, you do not have an attorney representing you. So if there's anything you'd like to say regarding the new trial, now is your chance to let me know any concerns you might have about it.
Only for the case that he says he did not get served, correct?
Yes.
Okay. I mean, no, I have no other questions. He makes up his own time card, so that's the only thing I have to say.
Well,
It's an app that you have to clock in on site.
Sir, right now, no one has asked you any questions.
Apologize.
Does everybody rest? Does anybody anything further they wish to present?
I rest, Your Honor.
Ms. Damani?
Nothing further, Your Honor.
Okay. Ms. Correa?
Nothing further.
I'm going to grant the new trial. And I'm going to reset the case to be heard. For anyone to file, consult lawyer. You may want to consult a lawyer, Ms. Correa, to file any necessary pleadings. If they do file a divorce, there's a good chance this will get consolidated with it and not be before me, but who knows? We'll reset it just in case, and then we'll see what's happening by the time that setting comes. July. What date would you like to use, Ms. Damani?
Judge, either September 30th or October 17th.
Will September 30th be enough time for everyone to prepare?
Yes, Judge.
No, not for me.
How much time do you
Judge-
need, ma'am?
I would like until October.
Judge, I would just like to let the court know that I am prep set in Harris County for a 3-day trial on the 16th, 17th, and 18th, I believe, of October.
The 18th is a Saturday? Do you want to check?
Okay, so then maybe it's Wednesday, Thursday, and Friday. Let me
So it's
see.
the 15th, 16th, and 17th. Okay.
Okay.
If we don't do that, we would be moved out to October 28th.
Okay.
That would work, Judge.
So the AG's office, like, yeah, well, Ms. Damani, are you going to prepare the order?
Miss Lewis, did you have an order?
I believe so. If I didn't file it, I can get it filed this morning. I apologize about that.
If you can send it to me, and then I can get it to Judge for signature.
Sure, will do.
Thank you.
Okay. Okay, then everyone is free to go, and we'll see what's happening on October 28th.
Thank you,
Thank you.
Judge.
Thank you.
My client has a number of safety concerns with regard to Ms. Woodfork and her home. She basically told my client to contact your lawyer or have your lawyer contact my lawyer, and she wasn't returning the kids to my client.
Saying that your client has no problem turning the children back over?
Oh, I'm saying we absolutely have a problem, but
I'm not going down that pipe today, sir.
The children have not been in school, I don't believe, for the last 2 weeks.
Everybody knows where everybody lives.
I don't want to share that information with
Just
him.
give me
Yes, Your Honor. I would like a final order today, but I don't think we're going to get to that point. So if I cannot have a final order,
There's a motion for enforcement also I didn't go into, but it hasn't been, there's been no citation or no service at this time that I can see that was filed earlier this month or last week. So obviously there's some things out here that still might be pending even after today. So you may proceed with that opening again, ma'am. Sorry about that.
if I can't get a final order, I'll take a temporary order setting the child support and medical support after a hearing. However, I'm not sure who should be paying the support. I do have some calculations for both parties, depending on who gets ordered to pay the support. And I believe that there will be zero medical support because I believe Ms. Woodfork can put the children on her insurance at zero cost. And then I would like appropriate findings on family violence, non-disclosure, and court costs. And I have no position on conservatorship, possession, and access, Your Honor.
All right. Thank you very much. I'm going to go ahead and start with you, Ms. Henson, since you're the counter petitioner in this matter. Well, you're the, according to the state, you're representing the non-custodial party, but that could be wrong. But this time I'll start with you, Ms. Henson, and then go to Mr. Gunn for an opening from his client. Thank you.
Yes, Your Honor. So we are asking for a temporary order today and that the case be referred to district court. At the time prior to today, when the party separated in October of 2024. They were living together with the children up until that point. The children, after Ms. Woodfork vacated their shared home in October of 2024, the children remained with my client and were with my client up until the last week of August of this year. So the children were living exclusively with my client. So today we are asking that the court reinstate the status quo, which had my client as primary conservator in this case, and then that the court make appropriate orders for possession and access with regard to the children. My client has a number of safety concerns with regard to Ms. Woodfork and her home, her other children and the activities going on in the home. So at this time, I do not know if it would be appropriate for Ms. Woodfork's visitation with the children to be supervised or if there just needs to be daytime visits. But we do believe that it's not in the children's best interest to continue to reside primarily with Ms. Woodfork. So that would be what our requests are today.
All right, and it's your allegation that, again, I hadn't had a chance to go over this, but it's your allegations that the father had the child, the children, and that the mother refused to return them, or that there's some violation of the standing order in this matter for that purpose?
That is correct, Your Honor. It's my understanding that there was an initial communication by Ms. Woodfork that she would return the children back to school the following Monday morning. This was, like I said, the last week of August. But then she didn't do so. There were a couple of conversations between the parties thereafter, and she basically told my client to contact your lawyer or have your lawyer contact my lawyer, and she wasn't returning the kids to my client.
Okay. All right. Mr. Khan.
Well, let's see. Good morning, Your Honor. The court is correct. There are motions pending in district court at this time. Both attorneys have filed motions objecting to an associate judge hearing a final. There, if we're going to operate under the local rules, there has not been a mediation attempted prior to final, but perhaps most importantly, as of right this moment, the individual, the other party, is not an adjudicated father of either one of these children. In fact, DNA was just filed, I believe, on Monday. I believe there was a request for DNA testing at some point earlier this spring. I had asked about this as recently as about 2 weeks ago, and it hadn't come back. Apparently, it's just now come back. I still haven't seen the results. So, if we're going to get into a temporary hearing today of some sort, that's fine. But there has been no, up until now, and as of right as we're speaking now, still is not an order adjudicating this individual as a father of either one of these children. So there's that issue. If we're going to go into other issues, we can touch upon the fact that the father has a rather lengthy criminal record, including convictions for family violence and some other crimes, including up to the felony level. So we have some concerns about him having possession and access at this time. I do need to further advise the court that in the process of attempting discovery, and I say that respondent has responded to discovery. It looks like both of us are listing multiple witnesses, lots of evidence, 20, 30 plus exhibits. So if we're going to get into a hearing on the merits, I would respectfully ask that that be, if we're not going to remove it, that be set on a special setting in person to allow both parties to present their evidence. The physics of the reality are that I anticipate 2 hours easily. And we've got exhibits, we've got other matters that need to be addressed, just the physics of entering exhibits and so forth that they're going to come forward. So there's a whole lot of things going on here. I do need to advise the court that I'm unavailable after this afternoon. So this was, for some reason, was put on a general docket, which is fine, but that's kind of our position at the moment. Again, is that there has been no adjudication of parentage to our understanding. I've been tracking this thing for a while, looking for it. I thought you had made an order at some point, Your Honor, and I don't believe you did.
Well, the original petition does request a determination of parentage. I did not. Okay. And then there was all the crosses. Everybody filed the standing order with all their crosses. The state filed theirs with theirs. And where the heck is that? Okay, and the order for paternity testing. Let's see, that was done back in June of this year.
Your Honor, if I may, there are DNA test results that show that he is the father.
Okay, well, I kind of figured that, but still. All right.
That would be news to me. I still haven't seen them, and they were just filed with the district court on Monday. So be that as it may, I realize that needs to be addressed, but.
All right, and you're saying that, okay. Okay, court.
And if I may address the court further when you're ready for just a moment on a housekeeping matter.
And it's your testimony, or I'm sorry, your opening that both of y'all have also filed district court.
That is correct, Your Honor.
Yes, Your Honor, and I don't mean, I'm sorry, ma'am, I didn't mean to cut you off.
No, that's what I was saying. You're good.
I was going to say, if I may.
Both of them were after the state filed theirs in 4D, correct?
Yes, Your Honor, I
correct.
checked. I don't mean to speak for the young lady, but it looks like hers was filed on February 3rd with item 2 as an objection. We filed ours originally on May 15th with an objection and then another on June 25th.
All right, same district court or different district courts?
Negative. They're all the same, and it's all in the same cause number, all coming out of the 169.
169.
Okay. All right, what's the other matter, the housekeeping matter, Mr. Gahn?
Negative. That was it, Your Honor. I believe the young lady beat me to it. That I figured you would want to know when was the objection filed. It was filed for all intents and purposes immediately. I believe the state filed their motion, I want to say, in December.
All right, this originally was filed in December, correct?
And Your Honor, if I may follow up, if the court does not have the time and ability to have a thorough contested temporary orders hearing today, which I completely understand and respect, we'd still just ask that the court to order the parties to go back to what the status quo was, where the children were in school in Bell County, as opposed to where the children are currently with Ms. Woodfork. I believe she's in Williamson County in Round Rock.
Judge, I have no problem with the school staying with the kids, but you know what I mean. We have no problem with that, and I've instructed my client to the same.
All right, then. So let's see. The first counter came in February. And before then, both parties had filed a request for hearing and made technically general appearances without an objection, folks. And you're aware of that, correct?
I'm aware, Your Honor.
Okay.
I was not.
Okay.
And Your Honor, we are fine if the case needs to stay in 4D court, but as counsel indicated, we would just need a special setting and more of court's time if ultimately we're going to remain in 4D court. I think our primary focus today, at least mine and my clients, is having the children return to where they were. And then if the court needs to set this down the line at a special setting, then be as it may. That's okay too.
Judge, there's no motion on file for that. At least, I'm sorry, let me correct. There's no filing set on that for today. It is only set for final. That's part of the concern. I do agree with my opponent. This would need a special if he retained it.
All right. Well, I plan on retaining it because, again, I've had the conversations with my DJs and believe this has come up quite frequently lately. And yeah, if it's my case, I got to set it up. I need to take care of it. And I don't mind doing live settings. I just got to find a date for it to be appropriate. And obviously, both the standing order does control here also. And Mr. Gunn, you're saying that obviously, I'm sorry, you're saying that your client has no problem turning the children back over?
Oh, I'm saying we absolutely have a problem, but I was addressing the second part of that statement, which was that if the kids need to remain in their present school, that's fine. It's not ideal for anybody, I suppose, but that's fine. Okay, well, again, he's as of 11:32 Central right now, he's still not adjudicated. There's no order saying he's the father.
We can do that right now.
That's about to happen, but there is no order.
Well, I'm getting ready to do it, Mr. Gunn. And again, anybody goes against the, they're before the court. They know, the technicalities are not going to fly with, will not fly 100% with violating the standing order. And if that's the case, then I will go ahead and have a hearing on that today. But as far as where I think the children need to go back to, but again, if I get the information that they were with dad, mom refused to return, I'm going to, even though both parties are properly before the court, both parties had received copies of that standing order, and it had nothing to do whether or not dad has been adjudicated the father. So that's going to be problematic. So we'll take care. Well, if we need to, we'll take care of it.
Judge, with all due respect, that is the entire issue. If he's not adjudicated as the father, he has no legal claim to the children.
Mr. Gunn, okay, and even if he wasn't, he probably has standing to file for custody anyway.
But they didn't plead for that.
I'm not going down that pipe today, sir.
Judge, I am. They didn't plead for that. If the court is wishing to proceed, I understand that. But I think that bears importance. That's the whole reason the state filed this.
Well, I'm getting ready to go ahead and have the state. This is set for final. I'm going to go ahead and have the state introduce the DNA paternity analysis, and we get ready to nip that part in the bud, and then we'll take care of everything else we need to, and we'll start looking at some dates, whether or not we need to set this up for a further temporary order with a live hearing, and whether or not we need, and what we're looking at as far as the final is concerned. But this time, I'm going to go ahead and let the state present her evidence as far as paternity, and we'll take everything else up after that. So at this time, Ms. Bexler, you're up, ma'am.
Your Honor, may I share screen?
Yes, you may.
Okay, Your Honor. Can you see that, Your Honor? Or shall I zoom in?
Yeah, you can zoom in a little better. So yeah, but I can see it.
Okay, so we have the child Jax Lee and then the 99.9%. And then if we scroll down, we have the child Venetia Lee, and that is also 99, actually 0.8, Your Honor. And I believe that this is on file already.
All right, well, I'm gonna have you mark those as state's exhibit number 1. And I'm going to start with you, Mr. Gunn. Go with you. The state, this was court ordered. These are the results for said for DNA paternity analysis for the 2 children. Is there any legal reason the court should not give these evidentiary consideration at this time, sir?
Negative, Your Honor.
All right, and Ms. Henson?
I have no objection, Your Honor.
All right, stage 1's admitted. Stage 1 shows that Mr. Walter Lee is the biological father of both children in conformity with the Texas Family Code of being at least 99.9%. So I will also find at this time. All right, then, guys. Yeah, he's dad. That's not a problem. Now, all right, right now, where are the kids going to school?
Not certain if mom has them enrolled in school or not, since she's had them.
They are enrolled in school, and she has been instructed to leave them where they are, which I believe, correct me if I'm wrong, I believe is the court, where they have been enrolled previously. I started to say Round Rock, but I think that's where she's living.
Mr. Lee, where did you have the children enrolled in school?
1 block over from my home, Cedar Valley Elementary School. Venetia had been in the school for 3 years. Jack's been in the school for 2 years.
All right, so where are they at this time?
With Ms. Woodford. Excuse me. Ms. Woodford, the court has a question for you.
Didn't copy the audio dump.
I'm sorry, can you repeat that?
Where are the children in school?
The children are still at Cedar Valley Elementary School. I never withdrew them from school.
All right, then, folks. Again, I'm looking at 1.4 under the standing order. Ma'am, you weren't allowed to remove them from their current the abode that was in place already previously. So you need to return it. And I'm looking at that. I'm looking at doing this as a final order, and I will not hold anything against anyone as far as what happened up to this point. Obviously, I'm going to do what's in the kid's best interest. If this was a little further out, I probably would point it at litem, but we're going to go straight down without an ad litem on this one and just go straight into final hearing.
Judge, may I address the court?
Yes, sir.
Judge, again, this do I understand this is over my objection? I do need to respectfully remind the court of 2 things. Number 1, the motion is, I believe it's filed. I don't know if it's been set already in district court for what that may be worth today. Secondly, up until a moment ago, this individual was not adjudicated as the father of these children.
Well, again, I didn't see anything in the standing order that said anybody had to be adjudicated for anything, Mr. Gunn. So the bottom line is, it said the standing order was to interfere with the abode, and mom did. So she
understood. Are my objections noted for the record?
Yes, they are. And, not a problem, sir. So I'm sorry, the judge lost his point. I was looking at this other case that got set that next. No, I lost the next Friday. The case from Heck is the next Friday. Never mind. All right, then, folks. Let's go ahead. I'll go ahead and set y'all up for this. I'm gonna give y'all all day if necessary. And I tell you, I'm gonna go ahead and set up a Zoom code. I also want to go ahead and set up one for a pre-trial to make sure everybody's ready to rock and roll on that date. And what I'll do is set up a 10:15 like I did this morning on one day the week before, just to make sure everybody's got their ducks in a row, everybody's ready to go. I'll close this down for a second. Sorry,
Judge. Do I assume that's your typical for attorneys only? Parties don't need to be present.
Oh yeah. Okay. I just want to make sure everybody's ready to rock and roll. And I'm looking at, since we're doing this on the October the 10th. Yeah, there goes family. Okay, no, I'm not doing family code. I mean the advanced family. That's next month. All right, so tell you what, let's do it the week of. Okay. I'll do it the week before. I got the week of is booked up really good too. So, all right, folks, let's go ahead and do a pre-trial on at 10:15 on Wednesday the 1st. Like I said, only lawyers have to show up. Let me know everything's ready to go. And anyway, of course, someone from your office can do it if necessary. Offices can do it. And the Zoom code you'll get for the 15th will be the same one that will be for the first will be the same one for the final on that following Friday. So at this point in time, is there anything else or any other questions or information that y'all need from me at this point? Thank you. Negative
not this time.
So 2 points of clarification. I heard earlier that we were doing in-person setting for the final. So are we doing Zoom for final? Because you said it's going to be the same one for the 10th.
Okay, I always set it up by Zoom code no matter what, ma'am. Okay, just because this is my recorder now, so there's always a Zoom code. But yeah, everybody, the Friday's going to be live, but thanks to Zoom having all these good, all this good recording and cloud capabilities, we record everything to the Zoom cloud. So, but yes, ma'am. But it's live on that date on the final, and on the pre-trial it is Zoom. And like I said, I anticipate it'll be over in 5 to 10 minutes. All right.
Understood. And then the other point is, Your Honor, with regard to the return of the children, is there any orders from the court with regard to how and when that's supposed to happen?
All right, what weekend is this? Let's see. Gotta go back into my calendar. This is this.
Because I don't believe
this is the second weekend of the month, so this is not the visitation weekend for the other party. So Dad needs to pick the kids up. Okay. I thought I was in September. I was in August. I'm sorry. All right. So this coming, all right, Dad needs to pick the kids up from school today. All right. This is not physical. We're out of visitation time frame. So the dad needs to pick the kids up from school today or have someone retrieve them from school today.
So, Judge, I'm sorry. So Ms. Woodfork indicated that she has not unenrolled the children from school. The children were enrolled in school in Bell County. Ms. Woodfork lives in Round Rock. The children have not been in school, I don't believe, for the last 2 weeks, but somebody may have to clarify that for me. So right. If that's the case, that means that the children...
I thought she said that she had not removed the children from their school at this time, but go ahead.
My client indicated she did not disenroll them. It's my understanding there was some sort of a family emergency in the last week or so, but I don't know that covers all the dates we're referring to. But be that as it may.
The children are not presently in school. She did not unenroll them, but they're not physically in school.
All right, here we go, guys. All right, ma'am, here's the deal. Everybody knows where everybody lives?
We are not certain about Ms. Woodfork's residence.
Man, what's in
I don't want to share that information with him.
Here's the deal. I'm the judge. I'll tell you what you're willing to share one way or the other, because again, I'm the person who's going to be looking at you in custody. I don't need your information, man. I just need to know what city you live in.
I'm in Round Rock.
All right, then. All right, ma'am. You're not at work right now, are you?
No, sir.
All right, sir. Are you at where are you located, sir?
I'm in my home. I'm in Killeen, Texas.
All right. Can you be at Round Rock at the Round Rock Police Department at 5 p.m. to exchange the children, sir?
I can.
All right, ma'am. Here's the deal. I'm going to order an exchange of the children at 5 p.m. this afternoon at the Round Rock Police Department. I haven't had to use these guys for a while. I usually use the Williamson County Sheriff's Department. But we'll go ahead.
Judge, you might want to specify Round Rock.
I am. I'm getting ready.
Yeah. Okay. Understood.
I'm getting ready to get the address. I'm well familiar with the Williamson County Courthouse, but not with the Round Rock PD. There we go. All right. All right. Well, they're on Main Street, so I know where that is. All right, folks. The Round Rock Police Department is at 2701 North May Street, and that's MAYS, just like Willie Street, Round Rock 78655. And that's where the exchanges take place at 5 o'clock. Obviously, it's 5 o'clock in Austin traffic, so everybody just remain there till the exchange takes place. All right. Anything else, folks?
Your Honor, is this just a reset or is it a temporary order, Your Honor?
This is a reset with the court making that order about the exchange taking place today.
Okay, Your Honor, I got it.
I have nothing else, Your Honor.
All right, Mr. Gaunt.
Negative, Your Honor. I'm good.
Sorry, Your Honor. One more thing. So
Yes,
the October the 10th is live in person. Where at? At the courthouse or?
Yeah, in my courtroom. Man.
Okay.
They booted me down. They booted me down here on second, so this is where we'll be.
Yes, Your Honor.
Ready. All right, see everybody then, and I'll go ahead and set up the pretrial and well, obviously the Zoom will be moved over for the appropriate time on for the recording purposes. But since it's live, we will not be broadcasting on YouTube on that date because that's a live date, so everything is confined to the courtroom at that time. All right, thank you all very much, and we're off the record, and I'll see the lawyers in about at the first of the month, and I'll see everybody back here on the Friday of the setting, and we'll go ahead and wrap this one up. Thank you.
Understood, Your Honor. Thank you.
Thank you.
Ma'am, you're free to go.
All right, we're off the record. Thank you.
Thank you, Counsel.
How did you discover that she has had another marriage going on?
We were filing for her paperwork to become a citizen, and I found an envelope with her personal documents in it. And when I discovered it, I asked her about it, and it was terrible.
Okay, Ms. Knott, what do we have?
Yes, Your Honor, this is a little bit of a different case. The parents had a pro se divorce decree that was signed in January of this year. And that divorce decree, it ordered joint managing conservators with the father to have a standard possession schedule, but the court did not set any child support or medical support because they found a potential fraud or misrepresentation of paternity by the mother when she got divorced from her other partner, Stanley, in 2024. The child, William here, was born during her marriage to Stanley. However, in that divorce, it said no children born of the marriage. And so when the parties on this case did the divorce, the judge did not set child support because of that issue. And so we did DNA testing. We have the results. They are positive. And so today we're just here to set current child and medical support. There's not an agreement on the amount or the start date for the medical support. So I'll start by taking testimony from the parties. I'll start by calling the father first. Sir, will you state your name?
Hezekiah Muhammad.
Okay. And you did DNA testing, correct?
That's correct.
And what are the results of that test?
They are positive. Thank God.
And Your Honor, may I share my screen?
Yes, ma'am.
Okay. Okay, Mr. Muhammad, can you see this DNA test report?
Yes, ma'am.
It has your name here and then William's name in the middle, right?
That's correct.
And showing the probability of paternity at 99.9%, right?
Yes.
Okay. I'd ask that this DNA test report be admitted into evidence as states Exhibit A.
So no. Oh, I'm sorry. Any objections?
Oh, no objections, Your Honor. Sorry.
Okay, no problem. Sorry, I should have asked you first. Sorry. Okay, it's admitted.
And Mr. Muhammad, you have health insurance for the child through the marketplace, is that right?
Yes, I have.
And does it cost you $150 per month?
That's correct.
And are you also currently employed making $13.50 per hour?
Yes, ma'am.
And you work 40 hours per week, is that right?
Yes, ma'am.
And you have William on this case, but you have 3 other minor children as well, is that correct?
That's correct.
Okay. And so based on the information, we've calculated child support at $281 each month. Are you in agreement with that amount?
Yes, ma'am.
And are you in agreement for that amount to start January 1st, 2026, and then monthly thereafter?
Yes, ma'am.
Okay. Is there anything else you want the court to know about your case?
No, ma'am.
Okay. I'll pass the witness.
Sure.
Yes. Very quickly. You heard the opening statement of Ms. Nutt, and you believe what she said is accurate concerning how the history of this case?
Yes.
And is it fair to say that you felt deceived by Ms. Izuchukwu?
Absolutely.
How did you discover that she has had another marriage going on?
We were filing for her paperwork to become a citizen, and I found an envelope with her personal documents in it, and when I discovered it, I asked her about it, and it was terrible. I don't even want to think about it again. It was really heartbreaking.
Now, let me ask you this. Did you know that Ms. Izuchukwu had gone and gotten a divorce from this person, Stanley?
I had no idea.
So that whole process that she started and did, she didn't tell you about it at all?
Not at all.
And is it fair to say that you felt deceived by Ms. Izuchukwu on different occasions?
Regularly.
And did that call into question whether or not, in your mind, you were the father?
Absolutely.
And when you went to court to do your divorce, it was a default judgment against Ms. Izuchukwu, correct?
Yes, sir.
But you had served her and given her notice, and she knew about the court proceeding.
That's correct.
And isn't it fair to say that when you did that divorce, it was the judge who decided not to order child support?
That's correct.
Because Ms. Izuchukwu had gone to court and lied directly to the court, right?
Absolutely.
Now, if you had when have you had access to this child, William?
No, I have not.
And if you had access, would you have gone and done a DNA test to confirm that you were the father?
Yes.
And if you were the father, you would have taken all of the responsibility and all that, correct?
Yes, correct.
And in fact, not even knowing the father, you were the father, you still tried to take on the responsibility.
I did.
And isn't it true that even though you were unsure about paternity, that you did even continue to send Miss Izuchukwu money?
Yes, I did.
You sent her $600, $300, $100, $200, $15, $120, $200, right?
Yes.
Through the period, this was for everybody listening. It was August 3rd through June 3rd that you made these payments, right?
That's correct.
Didn't you make additional payments from June 14th through April 7th of 2024 in the amounts of 200, 70, 53, 70, 50, 50, 14, 27, and 30, correct?
That's correct.
That's just some of the money you sent her, right?
Yes, sir.
Now that you are the father, that you know you're the father, you've always been the father, but now that you know the father, you're going to pay regular current child support moving forward without fail, right?
Yes, sir.
You have 3 other children and you always support them.
Yes, sir.
You have always provided insurance for the children and for William.
I have.
And you're going to continue to do that. All right, I pass this witness.
Okay. Representative, go ahead.
Yes, Your Honor, I'll call the mother. Ma'am, will you state your name?
My name is Ifeoma Ezechukwu.
Okay. And what's the name of the child on this case?
William Clyde.
And how old is he?
He's 2 years old.
Okay. And you saw the DNA test results that show Mr. Muhammad is the father, correct?
Correct.
Okay. And are you in agreement for the father to continue to carry William on health insurance to the marketplace?
Yes, yeah.
Okay. And based on Mr. Muhammad's income, we've calculated child support at $281 each month. Do you agree with that amount or do you disagree?
I disagree.
Okay. And can you explain why you disagree?
Okay. To start with what Mr. Hezekiah said, he lied. When we started dating, I told him I was married. I told him I was, yes.
Ma'am, I just need to know why you think the $281 in child support is not appropriate.
Because he hasn't supported me for this child from last year.
Okay.
Apart
So you
from the insurance and the
also,
money he sent to me. Sorry.
You also don't agree with the support starting January 1st. You want it to be
correct.
And so the 281, you think the amount should be higher. Is that correct?
It should be higher. Yeah. And again, it should be retro. Should start from, yeah. Should start earlier.
How much are you requesting child support to be set at?
From $450.
$450?
Yes, ma'am.
Okay. see. And William's last name right now, it's Clyde. Is that correct?
Yes, ma'am.
And whose last name is that?
That's his father's last name.
Mr. Muhammad's last name?
Correct.
Okay. I'll pass the witness.
Mr. Turner?
Yes. Very briefly, isn't it true that in February of 2024, you went to the courthouse, well, probably either in person or by Zoom, and you finalized a divorce from Stanley Izichukwu, correct?
Correct.
And at that hearing, you gave testimony on the record, correct?
Correct. I didn't
And
go. It
you,
was my
yes, sir. It's
my
a yes or no
attorney.
question, ma'am.
Okay.
And you told the court that there were no children born or adopted during the marriage, correct?
Correct.
And isn't it true that in January of 2025 that you were divorced from Mr. Muhammad?
Correct.
And by deceiving the court, you effectively denied yourself justice. It was you that did it, correct?
I disagree with what you said.
Well, if you had been honest at the hearing, then all of this would have come out and it could have been resolved at that time, correct?
I disagree.
Okay. That's all the questions I have. I pass this witness.
Okay. All right. I just had a couple questions, Mr. Turner, just to clarify. We're okay with the name of the child being the same, or it says Mr. Muhammad is his last name, but child is a different name. Are we leaving that the same, or are we wanting to change that?
That's a little unclear to me.
I'm sorry?
It was a little unclear to me whether or not Mr. Muhammad was trying to change the child's last name or not.
Okay, let me make sure then. Mr. Muhammad, the child is named after who? Is it the ex-husband or somebody else?
No, he's named after my mom.
Ah, okay. So are you wanting to leave it the same?
Yes, sir.
Okay, perfect. Just kind of weird. We have 3 different last names. Okay.
Well, he used to be Mr. Clyde, but he legally changed his name to Hezekiah Muhammad.
Yes.
Okay.
So that's where this comes from, Your Honor.
No problem. I just didn't want the child to be named after ex-husband or some other man. That's what was my primary thing.
I think if I understood Mr. Hezekiah correctly, is if the child wants to change his name to conform more with Mr. Hezekiah's belief system when he's older, that he can do that on his own. And that's kind of his decision, which I think is a good thing.
Yeah, I agree. Okay. All right. Let me go ahead and make a finding. I guess I'm including the order of paternity establishment, although kind of unusual. And as far as insurance, Mr. Muhammad's going to carry insurance. And then there's no basis for me to set support anything higher than the guts of the 281. I can't just arbitrarily set it at 450 because we don't like it. The 281 is calculated based on Mr. Muhammad's income, and that's what state law says should be paid. We had the opportunity, ma'am, you had the opportunity to set support in the divorce with Mr. Muhammad, but you did not participate. You didn't go to court. You didn't participate in the drafting of the orders. And then you also defrauded this court in your prior divorce by telling them that there were no kids born of the marriage. I know that a lot of people make that similar mistake, but you're supposed to tell the court if you had a child during your marriage, even if it wasn't your husband's child. What's supposed to happen when you do a divorce is this book should say so-and-so's child was born during the marriage, but the husband's not the father. That would be telling the truth. Leaving the child out just because, well, I don't think I want to put it in there, or you don't know what you're doing, isn't a good excuse. You have to put in all the information into your divorce. When you testified in court, you have to give them all the information, including that there was a child born, but it wasn't your husband's child. And so, you had kind of two opportunities to fix this, and you haven't. So I'm not ordering back child support or retroactive child support if you haven't done your part. So child support is 281 beginning January 1st, 2026, and monthly thereafter. There is no balance for the past. All right. The Attorney General's office will draft an order for me to sign, and then they'll send out withholding orders later on down the road to take it out of your check. And that should conclude our case. Y'all are excused and are done. You can press leave on the Zoom to exit out. Thank you.
Thank you very much.
Thank you.